Morning, everybody, or I should say good afternoon, and welcome to our online event, Bridging the Barriers. This year, due to COVID-19, as many of you are aware, we all had to take a different approach. And we decided that maybe some short little mini sessions would be of more of value to our members and to others rather than trying to have everybody sit in front of a computer screen for 4 or 5 hours. We would once again like to very much welcome Kim Stoll and Alan Cofman from Fernandes Hearn. We very much appreciate you being here today, and we thank you for your support. And we look forward to what you have to tell us today.
Kim, you will need to unmute yourself before you start, but you're welcome to go ahead whenever you like.
Hello, everybody. I'm really sorry that I can't see you and I can't be with you. But in these emerging days of the second wave, and we are all simply going back into it, I want you to throw your mind back to when this all happened and that beginning part of March. And I remember it well because my partner, Rui Fernandes, and I were in Brazil that week that the pandemic was declared. And it was pretty discombobulating is a very that's a word that doesn't even help us understand what was going on at that time. So we've all moved in, the world has changed, and we're going to talk about a little bit about COVID-19, but really how certain things have become more clear, including cyber issues. And of course, I'm going to address Drivers Inc. as well, because that's always a hot topic, whether it's COVID or not. Can we go to the first slide, please, Deb? Thank you. So I've been calling this whole time period a tectonic shift in everything we're doing. And that's for all 4 modes of transport, not just for trucking. But of course, that's what our focus is here today. And of course, I look at it as saying where there's a will, there's a way. Necessity is a mother of invention. We've figured out a lot over this time period as to how to handle everything. And that includes an unprecedented surge towards digitization and pandemic planning, because there is no return to normal, as we all know. Next slide, please. So the new normal, as I said, is talking about having, or is being in the forefront of using new technology. And firstly, what happened with COVID was we started using the technology we had to address a lot of the COVID issues. And of course, what's come out of that is certain new technologies as well. So you've got eyesight technologies that update driver monitoring systems to detect the use of face masks, for example. So that's an interesting addition. There's other technology that assists drivers with arrival and dock locations to encourage social distancing, assigning check-in by mobile app for door assignments to avoid having to enter into the building, for example. Next slide, please. So another version that you probably, many of you have seen, is the ArriveCan app, which allowed for 48 hours before arriving in Canada that truckers would be able to provide the personal information that's required by the border personnel. So you've got different contact tracing tools that include GPS and ELD, which help trace where the drivers are in terms of contact tracing in case there is a COVID event. You've got robotics that are moving goods from warehouses to trucks to avoid that social distancing, and increased use of electronic signatures. This is a long time coming, but we are seeing more of that. That reduces the requirement for paper documents to be exchanged. And so you've got documents being sent by email for confirmation, for example. So that's a good review of some of the different uses. Next slide, please. So with this digitization and this unprecedented push, as I've called it here, this tectonic shift, we're looking at a global market for AI in transportation to reach approximately $3.5 billion US by 2023. So that gives you AI, automation, machine learning, predictive and analytic tools, digital transformation, changes on how business operates, how they deliver value to their customers, how fleets interact with their customers, and they're just simply new efficiencies. to optimizing your fleet and to make sure that you're agile and can pivot when there's an unexpected obstacle. And it also requires a lot more or encourages a lot more collaboration. So basically, it's the merger of the digital and physical world, and that's what we're really in the middle of. Next slide, please. So customer expectations are there, but we have to figure out what's going to happen. Sorry, forward one again, Deb, sorry. Cyber vulnerabilities is where I want to be. So with regard to all of this new technology, of course, we're looking at vulnerabilities that come out of that. And so what I'm talking about here today will be cyber risks and cyber handling. We had a number of questions that related to cyber, so we thought that this was an important topic to bring. So increased digitization and interconnectivity problems, we've got those vulnerabilities that will show up. So you've got connected systems for transferring information, you've got human error, which is always a problem, of course, and social manipulations that come from working at home or within the office or on the road. Part of the problem are the aging and inflexible IT systems that some companies still have. The adoption of new technology has been slower than what we need it to be. And of course, you're going to have to think about within the organization training on recognizing phishing, baiting, impersonation, for example. Next slide, please. So there was a study done, I think it was Mimecast, within the first 100 days of COVID, and just look at these numbers. This is really interesting, and it will help you understand how scary this area is, because if you're not scared, you should be, and if you don't have the right systems in place and the right protections, disaster could be in your future. So please take this very seriously. So here are the numbers. Within the first 100 days, there's apparently spam and opportunistic detections increased by 26.3%. Impersonations detections increased by 30.3%. Malware detections increased by 35.16%. Blocking of URL clicks increased by 55.8%. Now, to be fair, I don't really understand what that is, but apparently it's bad. So every second there was global internet encounters of 15,000 malware sessions hitting victims, 15,000 phishing emails sent, 8,000 scanning attempts, 29% of internet traffic is actually considered harmful botnet traffic. And this last amount of if you can think of just the complete enormity of that, and of course they've got these automated systems scanning the web looking for potential victims. So it's not just the occasional email that you get, from the prince in a faraway country that's asking you to accept a deposit of $50 million because you took part in some lottery that you never bought a ticket for. This stuff is pretty serious. Next slide, please. So in trucking, of course, the main one of the main pieces of technology that will be at risk are ELDs. So my partner Alan and I were talking this morning just about where we are on ELDs, and we haven't really heard too much. We are looking at everyone being on board by June 12th, 2021. The ELDs are to be tested and certified by an accredited certification body because the ELD system, of course, is just key to connecting electronic controls and tracking all kinds of information like location, engine hours, driver identification, can include shipping and tracking, dispatching, has all kinds of information, really phenomenal, but of course there are vulnerabilities. Wi-Fi and Bluetooth are just two of the options. And functions actually go to the control of the engine and vehicle and the accuracy of the control console display. Next slide, please. So they can be compromised and they can be hacked. One of the questions to us was whether or not they could be, and of course they can. And of course, in that scenario, it's criminals accessing insecure ELDs to move into the business of the company. So The theft of personal information is a reality. Business and financial records can be stolen or copied. Location history, vehicle tracking, lists of customers and cargo losses, corruption or deletion of data. There's an infection of malware, preventing or delaying operations and shutting everything down. There can also be damage to reputation, of course, depending on who's been affected by all of this. Next slide, please. So what might that look like? So you might want to be aware of what it looks like, and this is one of the things that you're going to have to be speaking to your employees and dependent and independent contractors about as to what they might be seeing, depending on who's within your system. So problems might include unexpected incoming remote connections, non-reproducible equipment performance and maintenance issues, an increase in traffic on an internal network that's unusual, logs showing unexpected incoming remote connections, unrecognizable extension on files, files can't open, applications won't run, and sometimes it just doesn't feel like it's working right. So these are potentials. Next slide, please. So you've heard of ransomware. Ransomware until late 2019, most of the criminals were focusing on just encryption of victims' data. Now cyber criminals are looking at copying, transferring, and stealing your documentation or your information rather, and encrypting it at the same time so you can't use it. And this is all to do with increasing the likelihood that they'll be paid their ransom, which is always done in Bitcoin. And it'll cause, a full shutdown of everything when you become aware of it, or they may shut it down. Typically, what happens is that they will warn by email or some sort of communication to say that they've done this, and so you've got some indication before everything has to be shut down. But we'll get into what you can do about that. So the yearly average loss resulting from a single cyber incident in the transportation industry is typically estimated at $1 million for just that one loss, and it's increasing. Next slide, please. So the first thing that you can do is look at and do some due diligence, okay? So when you're putting in the ELD system, or if you already have, and you should have made sure of this already, if you have done so, the ELD supplier and manufacturer should be spoken to about their system and about their securities, what security they have within it. There's a recent FBI bulletin that you can access on the internet that talks about this entire subject. It's worth reading. There are best practices bulletins out there, including one from the FMCSA. You should be asking about the ELD system and whether it confidentiality and the integrity of communications. You should be seeing whether or not there were penetration tests performed on it to see how well it performed. Does it have a secure boot, which means, does it relate to all of the various devices that are attached to your system? Does it ship with a debug mode enabled? That means that you don't have to worry about it once you get it and it's already involved. So you have to know what you have. Next slide, please. So you're going to go, sorry, Deb, go forward, please. So it's after this one. Next one. Okay. Here we go. So next slide, please. We're going to get this right. Okay, here we go. So be proactive. This is the number one issue, actually. It's more important than, well, no, I shouldn't say it's more important. It's just as important, but really significantly important that you have insurance. Spend money to have the right insurance and talk to your broker to make sure that's the case. Now, it can be an add-on to your business insurance, but an add-on is never going to be the same or as good as a standalone policy. So you want to make sure that you get good coverage that's going to cover a variety of different type of infiltration and has a good response team. There are going to be forensics that will be provided. There's going to be a media response if that's required. And likely you've seen some of the media responses when these things happen. And also, and importantly, they will take care of the negotiations and payment. And as I mentioned, the ransom is always requested typically in Bitcoin. So I don't know how to get Bitcoin. I don't know if you do, but certainly that's something that the team, the response team that would be assigned by your insurer will be able to take care of. Forward one, please, Deb. So one of the things that you have to be aware of is that you might not be able to get that insurance if you're not cyber ready. So one of the things that you might have to do if you can't get insurance is to hire a cyber coach. And that cyber coach is going to help you prepare your business to be ready for insurance. Insurance companies sometimes will not provide insurance unless you have some basics in place. So you will be familiar, no doubt, with two-factor authentication, making sure that your personal and business files are separated, that certainly, there might be work at home issues with Wi-Fi. You want to make sure that your passwords are frequently changed and are difficult passwords, and you want to be constantly monitoring. So the IT person in your company, if I'm speaking to companies here, is not necessarily the only person or the right person to do this work. You need to have somebody who's actually trained to do this. So keep that in mind when you're thinking about going forward with your cyber insurance and your cyber readiness program. Next slide, please. So what happens if you are hacked? Well, the first thing you do, hopefully you have that insurance, and you call your insurer, who will dispatch a team and take over basically for that. But if you don't have insurance, you're going to have to arrange for a cyber team to assist with that cleanup, and that will be very, very expensive, which is why I'm suggesting that you make sure that you have insurance. There will be no doubt extensive forensics that have to be done to see what's been taken, what's been copied, what's been used. They're likely going to have to make sure that they're doing dark web searches and constant deep monitoring. Next slide, please. Okay, so from a cyber safety review perspective, we've talked about cyber insurance, but you want to make sure that your system is working from the front end to the end point. Please try to get rid of, try to switch out the legacy systems, the very old systems. Some people are still using very, very old technology. You need to get past that and work into your budgets to make sure that you're using much more up-to-date equipment, because the older your equipment is, the more at risk you are. So you want to make sure that your company is educated from the organization from top to bottom, so that everybody is aware of what they need to be looking for and how to handle things. So you need to communicate with cybersecurity professionals and legal professionals to develop an incident response plan, and that's what it's called. And also, hopefully, you can work with vendors and their due diligence as well. And remember, as we get more sophisticated, the bad guys get more sophisticated too. So it's an ongoing issue. Next slide, please. So now I'd like to move on to Drivers Inc. Hopefully I've scared all of you into making sure that you're going to review your cyber plans and where you are on that scale. So I really do encourage you to do that. Drivers Inc., of course, is always a hot topic. It's still an issue. I still get questions by drivers saying that they want to be independent operators, but when we look at what they've got, they aren't. And for companies that are still maintaining a Drivers Inc. stance, please be very careful. It's still, CRA is basically now considering this a fraud on the system. And it's not just from CRA, it's from all of the various corners where they are looking to see if you've signed up with 5 drivers, but you've got a lot more than that. It looks like they are not independent operators. They are, in fact, maybe employees or dependent contractors. Next slide, please. Okay, so just everybody knows, or maybe if you don't know, I'm going to review it here in any event, but there are advantages, of course, to hiring drivers as independent contractors. So no overtime is required to be paid. There's no entitlement to employee benefits like drug plans. There's no payment or withholding of employment taxes or other deductions. There's no skills training required. Of course, there's no rights under certain legislation like the Employment Standards Act. There's also no right to unionize, because they're not workers or employees as defined. There's no vicarious liability on the employer for independent contractors' activity, and as I mentioned, there's no need to take statutory deductions or withhold tax. Next slide, please. But of course, there are disadvantages. Some that they may obtain some expertise and then move on. They maybe don't know your company's specific needs if they are truly independent contractors. But the worst part is that if they are misclassified, you might open yourself up to penalties, which are expensive, and of course more exposure on liability. And there may be premiums that are payable that you should have been making and need to make in the future. Next slide, please. So independent contractors are not employees by contract, but the courts have started to look at this, and it's really an issue of whether or not they're employees in the economic sense, or are they dependent contractors in the economic sense. Employees would be entitled to a variety of different things, your group plans and so on. They're different than dependent contractors. Dependent contractors are entitled to notice if you dismiss them. They don't have all of the same rights as employees do. And of course, independent contractors are separate and apart from that. So because these actions generally only go forward when the relationship has soured, the existence of this kind of relationship, misclassified or not, may go on for some time before it's an issue. So really, we are looking at issues of exclusivity, control, and permanence. So let's go to the next slide, please, Deb. So it's determined on an individual basis. So it's very fact dependent. So each situation is going to be different. That's why we can't really answer these questions on the fly, because it is so fact dependent. Depends on what the situation is for the company and the particular driver or company involved that's doing the work. So it might include a contract between the parties. The issue is whether there's control exercised over the contractor. Whether they're an employee or not will be a common issue. There's economic exclusivity that you've got to look at. A creation of economic dependency, which becomes a real issue. You'll see that when I go through a couple of cases. And it's a non-exhaustive list. They keep on adding factors. So don't think that what I say here today is written in stone. It is a fluid list. If we go to the next slide, please. So let's look at the first case of any import that came along. It's called Mackey Moving Systems. It's from 2002. It's still good law. It's where we start. So the court looked at whether or not these particular individuals were dependent or independent contractors. And so the owner-operators here were all had the exact identical contracts, so there was no difference between them. They were using the company's CVOR operating authority. They had fleet insurance through the company. The license plates were in the company's name. The owner-operator had to reimburse the company for the cost of the plate. The owner-operator did not drive for anyone else, despite the permission that was in the contract that they could do so, but they didn't. And all of their income was derived from the company. Next slide, please. So further, in this particular set of facts, the tractors displayed the company name. The owner-operators attended and also paid for mandatory training. They were to maintain and equip their vehicles to company standards and inspections. They were required to maintain communication with the company, so where they were, whether they were coming in that day, had to advise if they were sick. The company controlled all their pickups, all their deliveries, their hours of work, their remuneration, their start time. And they were even considered salaried drivers for the purposes of the rules and regulations within the company. So it wasn't just one factor, but in combination. So this is a 2009 case, sorry, and then we went on to a 2009 case in McKee and Reed's Heritage, rather, that sort of expanded on this. But you can see that the court found here that the drivers were not independent contractors. Oops. How we're going here. I'm not sure what happened there. Okay, so sorry, if you can go to the next slide, please, Deb. So the next case is Keenan and Canuck Kitchens from 2016, and that case dealt with a couple who were working for Canuck Kitchens, and they were employees for 20 years, and then their status was unilaterally changed to independent contractors. So they became an independent contractor for the purposes of the paperwork. So they had no deductions for tax or CPP or EI, and they were completely dependent on the company economically, and they had the exclusivity for that company. And even though there was like a 10% amount of their work they did for somebody else, really it was all to do with the company. And so the court looked at a full history of their relationship with Canuck, and found that they in fact were not independent contractors. And that was the Ontario Court of Appeal. Can we go to the next slide, please? The most recent case I thought I'd bring to your attention is a case from this year. It's called Jack Gans Consulting Ltd. and Recipe Unlimited. This was a situation, again, where they were looking at whether a consultant was an independent contractor. And the court held that the plaintiff consultant was not an employee or dependent contractor. That he was not an employee or a dependent contractor. He wasn't actually an independent contractor. So this is the opposite way. There was no exclusivity. He was free to hire or a subcontract for services. He had other sources of income. He had there was not much evidence of control of the company. There were no codes of conduct or discipline that he faced if he acted a certain way. And he wanted to be an independent contractor at the beginning of the relationship. So this is a little bit different. We generally don't find cases that go this way, but in fact, the proof was such that he was not a dependent contractor or an employee, but rather he was found to be an independent contractor. Next slide, please. So what I have to leave you with is making sure that the classification of the independent contractor is appropriate. And this is whether you are the labeled independent contractor. You want to make sure that you are not going to be considered a dependent contractor if you are paying taxes, etc., as an independent contractor. And from the company's point of view, if you want to make sure that that classification is correct, of course. So you have to go through and make sure that that's the case. So what kinds of things are we looking at? You want to make sure that the owner-operator can haul for multiple carriers to avoid that exclusivity and economic dependency factor. Don't turn a blind eye to what's going on. Be aware of it. You need to be making sure that they're registering and plating their own vehicles, that they have their own insurance, that they are using their own operating authorities. They have to be responsible for fuel taxes and have proper contracts and notice periods, rather than self-interested changes. So you have to make sure it's in the contract, if you have one, that it's accurate. For anybody who wants to determine whether or not they are an independent contractor or whether the classification is appropriate, CRA has a very helpful checklist. There's also one on the workers' comp site as well. Next slide, please. So for the workers' comp site, there's an informational brochure that's very helpful as well, and you can pay for it identifies all of the various factors to make sure that somebody is considered an independent contractor, and here's the list here. It's what we've been talking about, and these are other factors that you can take a look at. You want to make sure that that there's a right to exercise a choice of selecting and operating a vehicle, and that there's the control aspect that we've talked about is there as well. So there's lots of help out there to get yourself identified as to whether or not you are an independent contractor or not, whether the classification is correct within your organization. Next slide, please. So again, this is just more of the same, so that we can, you're aware that the owner-operator is being registered properly as an independent contractor. Next slide, please. Okay, so what are the consequences? We talked about that generally, and it is going to be a situation where you may be liable to pay premiums or fines, etc., if you're found that you've improperly classified as an independent contractor those people who are actually dependent contractors or employees. And for the drivers, of course, you may have tax issues that you have to deal with as well. So back payments are going to be having to be paid. Next slide, please. So what's interesting, and this is still ongoing, the Omarili and Just Energy class action, these were door-to-door energy salespeople who were called independent contractors. And in fact, the issue before the court right now is whether or not they actually are. And so it's a class action, and it's going to trial in November of 2021 for 20 days. At least that's the schedule right now. It certainly was certified as a dependent contractor, and sorry, as a class action rather, and they are looking to be seen as dependent contractors so that they get proper notice in terms of dismissal and so on. So, so they could get unpaid minimum wage, overtime pay, vacation pay, public holiday pay, and premiums associated with the ESA, the CPP, and EI. Next slide, please. So it is different on the termination basis, where you have employees or dependent contractors. They're going to be required to receive notice of termination, which is what happens with, that's what comes from the common law, and it now applies to employees and dependent contractors. Independent contractors, of course, don't have to, so there might be requirements to pay statutory amounts, severance pay, for example, and I know that my partner Alan is going to be talking more about employment issues in his speech. Next slide, please. Just a brief comment on federally regulated employees. The Wilson and Atomic Energy case from the Supreme Court of Canada back in 2016 stated that there can be no dismissal of employees whether they are unionized or non-unionized, unless it's unless they're being dismissed for cause. So that's important to know, and very difficult to prove, of course, in some situations. Next slide, please. And there are some exceptions under the Canada Labour Code. The employee must have 12 months of service before they receive this protection, and it doesn't apply to managers. It doesn't apply to shortage of work situations, and doesn't apply to functions or where the function is discontinued. So next slide, please. So in the go forward, you know, make sure that and this is a go forward for both topics, make sure that your classifications are appropriate. Know what you are. If you are the driver, the company that is doing the driving, make sure that you've got an actual proper classification going on for both yourselves and for the company. Next slide, please. And we've already talked about that. If we can go next slide, please. And there we go. So thank you so much. Remember and take care of yourself for your cyber, and make sure that you've got your classifications in gear. In the interim, please stay safe and stay well.
Excellent. Thank you very much, Kim. I'm just going to bring up Alan's presentation. Oops.
Hi, good afternoon, everybody. Just as Deborah's doing that, I'll mention to Kim, I see that Jennifer McConnell has put in a couple of questions. Maybe I'll take a stab, Kim, at the first one, and maybe you could speak more. I mean, you spoke about the Driver Inc. business on the second. I don't know if you're still on the line with the microphone there, Kim.
Yeah, I'm still here, Alan. Yeah, okay. Go ahead with answering the question. I haven't looked at it yet, so I'm going to take a look now.
Okay, so the first question, which maybe I'll take a stab at, then you can tell me if I'm right or wrong. It says many shippers are requiring drivers to download an app on their phones, which they're required to log into and tracks their locations. What kind of liability does this open the shipper to? And actually, Kim and I were shown a few advanced questions that people had written in. And I'm going to be covering some in my presentation. This wasn't one, but Kim, actually, we might have missed one. I think there was a question that had asked about driver facing cameras, and maybe I'll take a stab at that while I answer Jennifer's question here. So outward facing cameras are pretty common and quite useful, and there isn't really a serious privacy concern. It's not capturing your every moment and so on. Of course, inward facing cameras are more invasive, and I think at the heart of Jennifer's question is about the privacy and invasiveness implications about tracking your sort of every move. It of course depends what jurisdiction you're in. If it's an interprovincial transportation company, you're probably federally regulated, in which case PIPEDA applies. That's the Personal Information Protection Electronic Documents Act. That PIPEDA Act, the federal act, is the default legislation that applies in every province unless the province has its own legislation. And other legislation, I think Alberta, for example, has other legislation is similar. So basically, collection, use, and disclosure are the privacy issues, and consent. So what is the liability to the shipper? Frankly, I don't think much if they're tracking their cargo. It's probably a good idea, in fact, on behalf of the shipper, in my opinion. It certainly would help with cargo theft, cargo damage, cargo loss cases. I'm sure adjusters would love to have that kind of information on an insurance loss. There is a slight privacy implication, so they potentially have some exposure under privacy laws if they fail to give consent, etc. But even then, under PIPEDA, really what happens is the complaint would go to the privacy commissioner, and there's no real teeth in the sense of monetary damages or anything like that. So with respect to tracking shipments, I don't see, frankly, much of a problem. I do imagine that drivers might find it annoying or frustrating. They don't like the idea of someone looking over their shoulder. So I guess if you were to deviate from a route, for example, beyond whatever their allowances are, that could cause issues. I know a former client of mine from when I was at my old firm had its own employee drivers driving from distribution centers to stores. And they had a system that basically shut off tracking them for pay purposes if they deviated. I think it was more than a kilometer. In any event, but generally speaking, unless people have follow-up questions, I don't think there's too much concern from a shipper point of view with respect to liability for tracking. Now, the driver-facing camera is a different story because, of course, it's much more invasive and it's actually not that useful. It could be useful, of course, in the case of an accident, for example? Was the driver paying attention, and so on? But even then, I would think that it would be preferable to have a less invasive option. For example, maybe a system that takes a snapshot as opposed to that's constantly monitoring you, and so on. Again, consent is required. So, and there's all kinds of permutations of this question of, really, to the extent that we're talking about privacy issues, but really, sort of a spectrum there. Outward facing cameras, I don't think there's much of a problem. Tracking, probably not much of a problem, but it is more invasive. By the time you have a camera stuck in your face looking at you all day long, then it's pretty bad and pretty invasive and likely not acceptable without appropriate consent. Kim, is that basically your feeling as well? Is there anything to add to that?
Yeah, it is. And on the second question, if the company is arm's length with the driving company, like you said, the question from Jennifer was that they pay the owner operator as a business, and then that owner operator has their own drivers who are who are Drivers Inc. It's an unusual situation. I haven't heard that one before, but ultimately, it would seem to me, subject to what Alan has to say, is that it's your own your own situation with the people that you've hired, and if they are independent, then I can't be responsible for what they are doing. It's your as long as there's no funny business in terms of how that's been set up, if that's been set up for some sort of convenience to the company. But if it's real in the sense that the company's relationship with the independent contractor that's directly responding to them is real and is properly classified, and there is no issue with regard to their drivers directly to the company, that I would think should be enough. Alan?
Yeah, I don't know. I don't think it's that uncommon. I mean, the issue, I guess, is, and the analysis could be potentially different from a CRA perspective as opposed to an employment issue. But if there's true independence, then it's not an issue at all. Kim went through the indicia in her presentation, but I mean, if there's a quote unquote independent owner operator, and then he's got a couple of drivers, or maybe just his brother or something, and there's no real distinction. He drives only for that. The two of them drive the same truck only for that company. Maybe they don't even own it, or maybe they own the tractor but not the trailers, and so on. It can get dicey. So I mean, basically, I think on a case-by-case basis, you have to look at the indicia that Kim ran through with the cases in her presentation. So the great lawyer line is, it depends. I think Kim.
It's so true. It depends.
Yeah. Okay. I love these questions because people actually care about them. So what I've done here is, you can see, my presentation. I'm going to go through it, but if people want to continue to ask questions as we go along, I prefer that, because then we're actually talking about what you all want to talk to. Okay, so there's my title page. You've all been looking at it for a while. If we could just skip maybe to the next slide. Okay, and so what I've done is I've divided this slideshow into 3 parts. I call them part 1, 2, and 3 because I'm not all that creative these days. But basically, the first question is really to respond to what I've called frequently asked questions, and I've included in there maybe not so frequently asked, but some questions that we were given in advance by people who'd written in. The second part, I want to talk about an important case that's actually going from the Ontario Court of Appeal up to the Supreme Court of Canada, called Walksdale, that has to do with employment contracts. And then the third part is basically the sort of the non-COVID issues. So the first part is sort of really COVID related. The second part is interesting these days, applies sort of COVID, non-COVID. The first, I'll say, by the way, is largely employee focused, the way I've drafted the slides, but of course the law works both ways. The second part is more employer focused. Again, it works both ways. And the third part, there was just some other employment questions about non-competes and non-solicitation agreements, Actually, I've forgotten the other, it escapes me. We'll get to it, but there's been a few other questions. Again, if anyone has questions as we go, happy to do it. If we could have the next slide, please. Okay, so this was just some background. It's already 10 to 1, so I'm not going to belabor any of these slides. But sort of implicit in what Kim was talking about is there's multiple jurisdictions. She talked about Ontario and federal. Of course, it's not just Ontario and federal. There's 14 jurisdictions, the provinces and territories, plus the federal jurisdiction for those who are federally regulated. Again, federal regulation applies basically to any transportation company who's doing business cross-border, whether that's interprovincial or international. Most of my slides and presentation are going to focus on recent COVID changes in Ontario, which are similar, as far as I'm aware, to other provinces, particularly British Columbia. For some reason, BC and Ontario often align that way, but I think also more generally across the country. But there have been some specific Ontario sort of strange machinations through our Employment Standards Act, and I'm going to try to go through that quickly. But basically, this legislation, the Employment Standards Act, I call it the ESA throughout a number of these slides, is really minimum standards. Those standards can be contracted out of. So if you have an employment agreement, it can alter those. So the employment standards, that's the minimum sort of base, generally speaking. Number one. Number two, the common law still applies. So basically the way our law works is nobody really knows what the law is. You go to judges, and judges make their decisions based on what other judges have decided. That's the common law. Kind of through small iterations over time, that's how we determine what's fair and just in our society. Legislation exists kind of to put parameters on that, but the common law is always evolving, and so there's a few kind of layers to this whenever you do the analysis. There's the common law, and then there's the minimum standards, and perhaps there's an employment agreement as well. Kim already spoke about that case, Wilson and Atomic Energy. So there are some important distinctions between Ontario and federal. Again, that's an important distinction. The Atomic Energy case is the one that said that, in generally speaking, absent certain circumstances, as long as the employee's been there 12 months and so on, you can't basically fire them. That was a huge change, 2016. So that's a big difference between Ontario and federal, for example. So we do have to be a little bit careful when we're doing the analysis. If you do have any of these issues, speak to one of us, speak to an employment lawyer, speak to an HR person, because these are broad strokes. Again, both regimes set out the minimum standards, and there might be additional rights. And again, those additional rights might not be under contract. It could be under another piece of legislation, for example, occupational health and safety or so on. If I could have just the next slide. Okay, so COVID. Here we are. Hot topic. What is and isn't a safe work environment? I think most people are aware or conceptually aware that the employer has an obligation to provide a safe work environment. That's not exactly defined. There's a bunch of indicia. Again, lawyers and judges get involved. So the Occupational Health and Safety Act is the Ontario legislation, similar legislation across the country. It doesn't specifically say, for example, that during COVID times, folks have to wear masks. But the employer does have an obligation to provide a safe work environment. So that may, for example, require masks or PPE in certain circumstances, or whatever. And really, it's got to be a context specific. I have in the bracket there as an example, wearing masks is something that's very reasonable for an employer to do. At our office, we require people to wear masks in the common areas and so on. But I say where there's no duty to accommodate. So if somebody has asthma or a breathing condition or another condition, then maybe it's not appropriate to have them wear masks. So again, some complication. In middle bullet, it may be reasonable to refuse work if your employer is not providing a safe work environment. And again, what does that mean? What is not providing a safe work environment? It depends. So it could be the nature of the work, the safety risk. So again, COVID analysis. Are you in an enclosed workspace or are you outside? Are you in close contact with other people? Are you able to maintain social distancing and so on? Could also depend on the specific safety needs of the individual. Maybe somebody has a compromised immune system and so on. So the overall circumstances matter. If your employer is not providing a safe work environment, you may be able to refuse the work. But here's the kicker. You could lose. So at the bottom, my last bullet, but if the workplace is deemed safe, then the employer can treat your refusal to work as a resignation. And that's a bit of a problem. If you resign, as opposed to if you were fired, as long as it wasn't for cause, then you'd be giving up significant benefits, including your right to severance pay and to benefits. And by the way, that includes EI. You know, if you are having those issues, definitely speak to someone to get some advice. The long and short of all that is the employer has a duty. You have a potential option to refuse work if it's unsafe, but there's a real significant danger if you're saying it's unsafe, but then you lose at the end of the day. Next slide. Okay, another hot topic. You know, workplaces functioning remotely or semi-remotely and so on. Maybe people are in self-isolation or quarantine and so on. First bullet, employers are not necessarily required to pay employees who can't work, and that includes if somebody's been so if somebody's sick or somebody's been in close contact with someone who has COVID-19 and the employer sends you home, they're not necessarily required to pay you for your time. That's a bit of a shock to some folks. Later in the presentation, I'll get to a program that's supposed to address that. Bullet number 2, if the employee can work from home, then she or he ought to be accommodated and paid their regular pay and regular benefits. You don't get less pay and so on. I had a sub-bullet there. Employer must accommodate to the point of undue hardship. And they might also have to take other steps, as I have in the next bullet. They might have to help you get set up. Maybe you need a computer for home. Maybe they need to give you training and so on and so forth. So the employer has obligations, and they're going to need to facilitate the transition. Employers may choose which employees can work from home and which ones work from the office, and this will lead into one of the questions that we got from the audience. But the long and short of it, as in everything in employment law, the employer is not allowed to be discriminatory. And I'm going to get to that discriminatory bit when we talk about the audience question. And last bullet there, employees may be able to use vacation days, sick days, banked overtime, and so on. But of course, there's a limit to that. People don't want to do that. And so, but that is an option. Next slide, please. So this was one of the questions. I'll just read it verbatim. It says, I was laid off during COVID-19 due to company cutbacks. When operations returned to normal, I was not notified. When I inquired, I was told that I was no longer needed. I received no severance pay. They put another person in my position at reduced pay. So there's a whole lot of things going on here. I can't exactly give legal advice, one, because I can't in a forum like this, but also because there's just too many variables. So one of the questions here is potentially that discrimination bit. And so there might be a human rights issue. There's a question here about the layoff length and whether it was reasonable. If an employer is unable to bring you back after your severance, then they can they're going to have to make a decision, really, you know, whether or not they want to terminate you or not. And of course, there's consequences for terminating employees. But you're on layoff when you're on layoff, and that's job protected layoff. And then when you're no longer on layoff, then the employer has that decision: do they want to terminate you or not? There's a whole bunch of issues surrounding it, who gets called back first and so on. So there might be union rights in the union environment. Again, most of these are not union. This is really employment, non-unionized issues. You know, your employment agreement they might talk about seniority and so on. And actually, I'm seeing that Jennifer's sending another question about picking up freight in the U.S., and that was actually along the lines of one of the questions that we have. So I'm going to get to that in a second. In any event, if you do have these issues along the lines of this questioner, you can potentially either go to the tribunal or take court action. But I think here the issues are sort of, is this person laid off, or are they being terminated? If they're being terminated, what was the reason? and it's potentially constructive dismissal, which we'll get to later. Basically, constructive dismissal being where you've effectively lost your job without being told. Next slide, please. Okay, there are 15 people was the question in my department. Only 5 are men. All the women were laid off and not a single man. Some of the women had more experience and more seniority than the men. So again, there's a number of questions here. One, is it a layoff or is it a termination? Maybe constructive dismissal again. What did the men do? What did the women do? I'm not sure. If it's a trucking company and the men are drivers and the women were dispatch and office workers and so on, then maybe the men were needed and there's a reason for it. So the reason matters significantly. Of course, on its face, this looks terrible. So on its face, this is a potential human rights issue. I've listed there, all the different various human rights issues. It could be race, color, sexual orientation, you name it. That's the list. So this does look like a potential human rights dispute. The other thing I'll mention about human rights disputes, by the way, is you might be right and a person might be racist or sexist or what have you, but there's some danger in making a complaint when you don't have sufficient evidence. So you will have to convince a tribunal at the end of the day, whether you're federal or provincial, whether it's Ontario or somewhere else, that was what happened. The person might have a justification for it. Just because you feel it's right, or maybe you actually are right, the evidence matters, and unfortunately, it's not unlike other legal processes. So there's protections there, but only to a point. Next slide, please. So I think this is what Jennifer's getting at. I don't feel safe crossing the border. My company says that they'll fire me for refusing loads. Can they do that? So again, it depends. There's no principle that your employer can't send you to the United States. That was your job. I assume it was. But there's hotspots in the United States and people have health issues. Maybe you're taking medication that makes your immune system compromised and so on. So employers in those kinds of circumstances might have an obligation to accommodate. And the kinds of accommodation might be, for example, they'll send somebody else to the United States and they'll send you to do a pickup in Ottawa or Thunder Bay or something. It depends. It depends, but just as a general principle, no, you can't just refuse work because you feel unsafe. You have to actually be unsafe on some sort of ground. Again, that goes back to the duty of providing a safe work environment, and maybe it can be mitigated. Maybe the employer will provide you with sufficient equipment and so on. Maybe, but just on the question as it's presented, there's not enough facts for me to get there. So, without more, you would have to probably go to the United States. Next slide. Okay, I'm going to start going through a couple of these slides a little bit faster because we have about a half hour left. Issues that people talk about and sometimes conflate. A leave of absence. A leave of absence is something maybe maternity or paternity leave. That is a paid leave or unpaid leave, depending on which one you're taking. Temporary layoff. Again, this is a job protected layoff. Sometimes people mix a layoff with being fired. Those are different issues. So termination and layoffs are different. If you're laid off, you still have rights and you might be recalled. If you're terminated, then the question is really whether it was for cause or not for cause, and then what are the consequences of that. So the next two bullets, there's these different types of termination. Constructive dismissal is basically a type of termination where we'll get to it. They're basically terminating you without telling you. They might have changed your role or your pay or your job description or your opportunities for advancement and so on. So effectively, they've given you a lesser job or dismissed you. Okay, so let's go to the next slide. Again, the Employment Standards Act provides minimums. They can be altered by agreement. I note there, employees, by the way, cannot be punished for asking about their rights. So you might be a pesky employee who's concerned about your rights and talking to your employer, what are my rights? Can I refuse to go to the United States and whatever? You can't be reprimanded for that. Again, there's human rights legislation, occupational health and safety, and so on and so on. Next slide. So these are just a list of the ordinary leaves of absences, and I post this up there just because next is going to come the COVID weird ones. So ordinary leaves of absences, again, pregnancy or parental leave, sick leave, bereavement leave, and any one of these on the list. I have a note there. Note: employers cannot convert leave into vacation time. Leave is leave. It's not your vacation time. You're entitled to your vacation time. Next slide. Again, still just on the basics of what does it mean, a leave of absence. This is what I call ordinary leave. It applies to all employees. Doesn't matter if you're full-time, part-time, contract, what have you. Leave, again, is job protected. Leave does not mean you're fired. It's actually job protected leave. You're entitled to return to the same position. They can't put you in a different position, a lesser position. So if somebody was filling in for you, they don't get your job. You get your job when you come back. You can't be fired or punished for taking the leave. So if you have taken leave 3 times because you had 3 kids, you're entitled to do that. Next bullet: if the position no longer exists, then the position no longer exists, but you're entitled to something comparable as far as possible in the circumstances based on your skills and seniority and so on. Next slide. Okay, so ordinary job protected leaves, the ones we just talked about, parental leave and so on, those remain unaffected. But there's a couple of new weird ones, and these were put in this new Reopening Ontario Act. We in the early days of COVID, we were under an emergency act. We no longer are. Basically, all the COVID emergency has been shuffled over into a new piece of legislation called the Reopening Ontario, a Flexible Response to COVID Act. So the Reopening Act. And the Reopening Act has a couple of new types of leave, and these matter because of a deeming provision. I know it's all kind of legalese, but I'll try to make it make sense. So there's your ordinary leaves, which we talked about, and then there's 2 new ones: the infectious disease emergency leave and the declared emergency leave. I know that sounds like the same thing, but we'll get to what they are. So next slide. So under regulation to the new act, there's this thing called the infectious disease emergency leave. It basically means you're whacked with some sort of COVID issue. You're sick. You need to get tested. You got a positive test. You're in close contact with someone. You're subject to an order, and so on. If these affect you, then you probably are subject to what's the infectious disease emergency leave. So you're on leave because of COVID, basically. Next slide. The declared emergency leave works for a different period. These are both, by the way, retroactive. So the infectious disease one that we just talked about applies to a specified period, which is going to expire on January 2nd. The declared emergency leave is backwards looking, not forward looking at all. And it basically applies to the time of the emergency, which was mid-March to the end of July. And so that applies if you're not working, 1, because of the emergency, and 2, because of one of those other bullet points that I have there. For example, you're subject to an order under the Health Protection and Promotion Act or something. Now, in order to come within this declared emergency leave, you have to have been directly affected. So if you're the owner of the business, you're probably directly affected. If you're an employee, it doesn't apply. So anyway, I know that's all a bit weird, but there's these 2 leaves, the infectious disease one and the declared emergency one. How do they matter? Let's go to the next slide. Okay, so I'll get to them in a second because there's a layoff where you're deemed to. Okay, so back to layoffs in ordinary times. Then when I get to COVID, it'll all come together. In ordinary times, a layoff is not a termination. Hours are cut back or they're stopped altogether. You're entitled to recall, as we talked about. There's a specified time, so you can't be on layoff forever. It's usually about 35 weeks. Past the specified time, if they don't call you back, then you're fired. That's a termination. On termination, you're entitled to get your notice. That's either pay in lieu or actual termination notice, and you can work it out. And if you're a longstanding employee in an appropriate setting, then you might be entitled to severance as well. So basically, you're entitled to be paid your due if you can't be brought back after the termination period. Next slide. So that was ordinary layoffs. Now COVID layoffs. So the special regulation under that Reopening Ontario Act applies for COVID stuff. So that's bullet number one. Bullet number two, a person whose hours are reduced or eliminated is deemed to be on job-protected infectious disease emergency leave. Now, this might sound great, but it's actually terrible for some employees. We'll talk about that in a second. Because basically, the next bullet point, the layoff clock stops ticking during this period. So ordinarily, they have to call you back. But now they're entitled to keep you on temporary layoff until January 2nd. So time doesn't start ticking again until January 3rd. So if you're, kind of basically en route to be fired, you're not going to know about it until, February next year. That's kind of a year after COVID began. So, that effectively legislates away a bunch of rights and claims. Next slide. So once the COVID period ends, that's when the employer they're going to have to make this decision. Are they going to fire you or not going to fire you? So as I say there, some employees might not actually be laid off until September 2021 because of the way the timing works. So as I say, this is very employer friendly. But then I have a note, recall, remember common law applies. So you can seek to get a declaration that you were terminated or constructively dismissed. Which some employees might need to do. Next slide. Constructive dismissal. So basically, it's termination without cause. I mentioned it a bunch of times. There's a whole bunch of indicia about what is or isn't constructive dismissal. These are some of the things that a court or tribunal would look at. Was it a demotion, an alteration of your job description, an alteration in your working conditions? Maybe your office was closed and you're put in a crummy desk in the corner and it's not quite the same. Lower wages, lower compensation in other ways, changing your work hours, and so on. Again, imposing a leave of absence without sufficient reasoning, for example. And this is just some of any number of things that could lead to a constructive dismissal determination. Next slide. Okay, so I'm going to get into this one because it's going to also explain a bit about what's coming up in the slides. Okay, you're dismissed. Of course, it can be with cause, without cause. If you're fired for cause, you were stealing from the employer, then you're kind of up a creek. You're not going to get anything. If you're fired without cause, then you're entitled to your entitlements. The Employment Standards Act, again, is a minimum. You can change that by contract or otherwise. Remember, the common law is actually more generous than the minimum in the Employment Standards Act, but the common law is going to look at all kinds of factors. They might include age, length of service, what kind of position you had, et cetera, et cetera. Next slide. These are the ESA minimums, not a lot. We can go to the next slide. Of course, if you're again fired for cause, it's an issue. The one point I wanted to make on this slide is that the common law and the Employment Standards Act are a little bit different. Under the Employment Standards Act, there's a definition. You have to have been guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. As opposed to the common law test, was there just cause? So the willful misconduct is a little bit harder to make out. So the common law and the Employment Standards Act are a little bit different in that regard. Next slide. All right, I'm going to breeze through this one a little bit quickly, but of course another hot topic is all these government benefits. There's a bunch for employers also. There's the rent subsidy and on and on and on, but this is really focused on employee rights. So there was the CERB. The CERB isn't really acting anymore, but you can retroactively apply for it if you were entitled to it. CERB was replaced with the CRB, the Canada Recovery Benefit. You get $500 a week. They pay it every 2 weeks. You get it up to 26 weeks, but they claw some back because it's taxable. It basically applies even to self-employed people as long as you lost at least 50% of your income. One of the other things we talked about, there's these questions of leave and my vacation time and all this stuff. Now there's this benefit called the Canada Recovery Caregiving Benefit, which you might be entitled to, only one per household. So if there's, two parents and a child, and the child needs care, both parents can't take the benefit, only one per household. But basically you can't work at least 50% of the week because you're taking care of a child under 12, or some other family member who's sick for COVID reasons or is at serious health risk. Another one, the Canada Recovery Sickness Benefit. So if you yourself are sick or you have to quarantine or self-isolate, there's another benefit. So, and there's a whole slew of other ones, but these are the ones that are really employee focused as sort of wage supports. Next slide. Okay. That was the biggest part. Those are kind of the hot topics as I saw them. Part 2 is this case called Walksdale. Went to the Ontario Court of Appeal, is now going to the Supreme Court of Canada. It basically says if you have an employment agreement, there's very, very likely a problem with it. This case sent shockwaves all throughout the legal community for a couple reasons. It's pretty crazy if you ask me, so I'm just going to run through it because everybody should be aware of it if you're an employer or an employee. Next slide. So by the way, this is Ontario case law, but it may or may not be followed in other places, or who knows, even federally. So it's this case called Walksdale. The plaintiff had a position called Director of Sales, and the contract says this is what happens if you're fired for cause, and this is what happens if you're fired without cause. And it says you get paid X and you get paid Y. So he gets fired, and the employer says, we're not going to be jerks. We recognize that you're not fired for cause. It's not for cause. So we're going to pay you. Your agreement says that you get X dollars. So here's your X dollars. So sorry it didn't work out, and see yourself to the door. And he sues. And let's go to the next slide. And the Court of Appeal struggled with this question. Well, we looked at the contract, and the for cause provision really troubles us because it's offside the Employment Standards Act. I think he was only given a week of pay or something. He was entitled to more even under the Employment Standards Act, but he wasn't terminated for that reason. Remember, he was terminated not for cause. So they have a problem with the for cause clause, even though this guy was fired for the other reasons. Other clause applied, not for cause. But the court says, no, we don't like this. So they said, due to the illegality of the for cause provision, we're going to call the whole thing junk, and we're going to say it was no good. And so the effect of that was, since they threw out the employment agreement, the employee was entitled to the common law provision. Remember, common law is generally more generous than the employment standards minimum. Next slide. So say plaintiff wins because who would have thunk it? But he did. This is a quote from the court. It says, while courts will permit an employer to enforce a rights-restricting contract, they will not enforce termination provisions that are in whole or in part illegal. In concluding this analysis, it is irrelevant whether the termination provisions are found in one place of the agreement or whether they're linked. And nobody ever would have thunk that that the clause that was no good didn't even matter because he wasn't fired for that reason. But there we go. So that's the Ontario Court of Appeal, one of the most persuasive courts in the country. And this is what they say. They say when reviewing an employment contract for enforceability, you should have the following things in mind. You read the contract as a whole in a way that best encourages compliance with the minimum standards, that protects employees, and that extends the ESA's protections to as many people as possible. So, wow, it couldn't be any more employee-friendly, employer-unfriendly. So that's an interesting question then. Is that limited just to the Employment Standards Act? Does that apply to other sort of situations that deal with employment, like the occupational health and safety regimes? Where does it end? Who knows? Next slide. And on top of all of this, there was lawyerly language, the stuff that we like to put in pretty much every agreement. In fact, as we're speaking, I'm getting emails popping up I'm assisting in the negotiation of a purchase and sale of a business, and we have what we call a severability provision. Now, interestingly, Walksdale deals with severability. Severability basically just says if one of the provisions of this agreement is deemed unenforceable, no problem, sever it, throw it away, and the rest of the agreement will continue. And that's in all kinds of agreements. It's been there for, I don't know, probably hundreds and hundreds of years. They're pretty standard. But anyway, the Court of Appeal says, no, we don't like the severability provision. Throw that away too. We're going to read it only as a whole. Next slide. Here they say, this is the quote, a severability clause cannot have any effect on clauses of a contract that have been made void by statute. I don't really know what that means because only the unenforceable provision was made void by a statute, but they go on. Having concluded that the termination for cause provision and the termination without cause provision are to be understood together, then the severability clause cannot apply to sever the offending portion of the termination provisions. So I don't know what that means. Does that mean just for employment standards? Is that just restricted to termination provisions? What is the principle that they're throwing out severability? I have no idea. Next slide. So, lawyers always say, I don't know what that means, and it depends on this and it depends on that. And clients hate to hear it, but what it really means is that there's, thousands, maybe millions of contracts out there that are potentially problematic. I mean, you might be firing an employee. It might be for cause, it might be for not for cause, and the other provision is offside the ESA. So what do you do about it? You have to update it if you can, but it's not that easy. One of the other principles in Canadian law, especially Ontario law, basically all Canadian law outside Quebec, is that there has to be consideration. You have to give something to get something. You're going to give me that Snickers bar, I'm going to give you $1. That's the exchange of value. You need that in order to have what we call consideration. So if you're going to change somebody's contract terms, there's got to be an exchange of consideration. So a good time to do that if you're an employer is when you're giving somebody new consideration. So when someone's getting a promotion, they're getting a new title, they're getting more vacation time, they're getting more pay, that is a time to consider updating your contracts. But right now they might be bad. Who knows? It's a good time to reprise and to take advice and figure out how to go. But basically, there's a serious issue here for contracts. There's a serious issue about severability. I should say this is all going to the Supreme Court of Canada, and with any luck, the Supreme Court is going to say, no, the Ontario Court of Appeal is a little bit overboard. Nothing has really changed. We'll see. Okay, we have about 7 minutes left, and I think I only need about 5. So let's go on to the next slide, which I think should be part 3. Yeah, part 3 was what COVID, other issues. So there's 2 other questions. Let's hit the next slide. Yeah, right. So this one, someone was asking, my company told me that I can't have ride-alongs in my truck, no riders. And they told me the reason is for insurance issues, but I asked the insurer and they told me they don't care. I can have as many people as I want, or I can have a rider or whatever. Why is the employer lying to me? And question number 2, are waiver forms not enforceable? So basically, there's lots and lots and lots of good reasons why an employer would not want you to have someone to ride along. So from an insurance point of view, I'm not an underwriter, but I would think that the risk is minimal. But from an employer's point of view, the risk is probably not minimal, especially if you're going to be accessing secure yards and so on. That is a problem I had at one time. I had a cargo issue where someone had smacked into a loading dock at a distribution center and his rider wasn't allowed to be there. It was a huge problem. Also, just generally, it's a regulated workplace. This even includes, smoking regulations. What if the guy's smoking? Are you inside those regulations? And on and on and on. Basically, from an employer's point of view, nothing really good can come of it. As for waivers can be problematic. I refer there to a case called Crocker and Sundance. It was kind of an amusing case to read in law school. Some guy, he's like a beginner skier. They feed him lots of food and tons of alcohol, and he does an inner tube race on the moguls on the top of the mountain, and of course he hurts himself. He had signed a waiver. The question was whether the waiver was enforceable, and of course the court wanted to find in his favor because he was pretty hurt. and the waiver wasn't enforceable. There's a bunch of issues about, did they know what they were signing and whatever. And the bigger problem actually is, you have to be pretty narrow to cover off every circumstance. The problem with litigation is people get in trouble that weren't foreseen at the outset. So waivers are not the best. I mean, they're something, but they're not the best way to take care of liabilities. I have 5 minutes left, and I think I only need about 3. So next slide, please. And I think this is the last question, but then I also see that one was emailed in the chat function. Question here, a potential future employer wants me to sign a 2-year non-competition agreement. That's a long time. Is it even legal? So there's all kinds of what we call restrictive covenants, an agreement, a contract that says you can't do something. Courts don't like restrictive covenants. The main two that you probably heard about are non-competition agreements and non-solicitation agreements. What's the difference? Non-competition agreement says you won't compete with your employer. Basically, you won't do the same thing. You won't be in the same business at all in the industry with them. You're not going to compete with them in any way. Less severe than that is what they call a non-solicitation. So, okay, you'll still do the same business. You'll still be in the same line of work, but you're not going to call your old employers contacts, clients, and so on. That's non-solicitation. And there's various permutations of this. For example, there might be a provision for non-solicitation of employees, and so on. For a while, not so much recently, but maybe 3 or 4 years ago, and for a period of about 5 years, for some reason, there was a slew of these, where basically people were poaching their former employers' customer lists and so on and so on in the transportation world. I'm not sure why. Any event, restrictive covenants, very difficult. Non-competition, very, very, very difficult. The court prefers to see non-solicitation. And again, it's one of these things that depends on the circumstances, but they're going to look at things like how long is it, what's the geographical location, and so on, because they don't want to take away your right to a livelihood. And then the other thing in considering all of these is, even if an employer has somebody sign a non-competition, non-solicitation agreement, they're probably not going to be able to do much about it. They're going to sue you, maybe. And maybe they're entitled to, maybe they're not. But, the idea that they're likely going to be able to get some sort of injunction to prevent you from working in the industry while litigation is ongoing is almost nil. It's really, really hard. So, it's a difficult thing to sign as an employee, but its enforceability is quite questionable, but specifically if it's a non-compete as opposed to a non-solicit. I think that's the last slide. Yeah, and I'm just going to check out the written question here. Drivers are to pick up freight in Canada, then stop in the U.S. to pick up additional freight. Yeah, so there's interlining issues. This I've done a whole presentation on. It probably goes beyond what we could talk about today. But basically, if you pick up freight in the U.S., if you meet a whole bunch of rules, then you can do it so long as you don't deviate from the main route. So if you're picking up at the same place that you dropped off, or you're picking up on the way, then probably, but not necessarily. If you're making a special effort, then it's called cabotage. There's anti-cabotage rules, both for Americans in Canada and Canadians in the U.S. You can't do it. So there's a general prohibition against making 2 pickups in the U.S. if you're Canadian, with some exception. So it might be okay. It's probably a problem. It's a pretty complicated question. I am happy to speak about it offline. Kim,
Sorry.
Do you have any questions, comments on all that? Was I right? Everything?
Yes, you were. On the cabotage question, I did write an article for Truck News or Today's Trucking on that issue. So if you just Google it, you can probably find the article. That'll help answer any questions, hopefully, on the cabotage question. If not, please feel free to reach out to Alan or myself, and we can help you with that.
Yeah, actually, I have a presentation up I did for the Canadian Transportation Lawyers Association. Just Kim's article basically was my starting point. Hers is better. Start with hers. But the reason I mentioned the CTLA, Canadian Transportation Lawyers, because there was an American who was at that conference, and he gave an American perspective if you're interested in what can Americans do in Canada. So Kim's is your starting point, and then Google the CTLA if you're interested in how it works the other way around.
Excellent. Well, thank you very much, guys. That was a fabulous and very informative presentation. I really enjoyed it. Any other questions that we have that come up after we'll definitely reach out to you. But thank you very much for your time and your information.
Sorry, Deb, one more thing.
Yeah.
Anybody watching doesn't receive the Fernandes Hearn monthly e-newsletter and wants to receive it, please reach out to either Alan or myself. We'll send you the anti-spam consent, which you don't actually have to sign. You just have to respond to it saying that you'd like to receive our newsletter. So please feel free to do that. All the newsletters are available on our website, but there is some delay. So if you want the current one, and in the form we send it to clients, please just reach out and we'll make sure that you get on our list.
And actually, it's worth it because there's announcements that aren't on the online version and jokes. It's worth it for the jokes.
And the photographs. So anyway, so it tells it, and it also tells you what Alan and I and our partners and the associates here at Fernandes Hearn and our team are up to these days. Now in this day of COVID, not too much. But we are doing webinars, and certainly there's a lot of things that you can participate in, and it's a great way to keep in touch with us on a monthly basis.
Excellent. Thank you. All right, everybody, that's the end of our presentation. Have a lovely day.
Thanks, everybody.
Stay safe, stay well.
Thank you.